In this lecture, we shall discuss interpleader proceedings. We shall have this discussion within the context of the Civil Procedure Rules as applicable in Ghana. Now, there are times when a person can bring an action against a defendant for the recovery of money. And then judgment will be given in favor of the plaintiff to recover an amount of money from the defendant. As we dealt with in our previous lecture, one of the modes of enforcing a judgment for the recovery of money is through or by a writ of fife. And this writ of fife is executed by seizing property belonging to the judgment debtor and having it sold so that the proceeds are what we will use to pay the judgment creditor. In our previous lecture, we discussed that if there's a movable property like a car that belongs to the judgment debtor, we can seize that property and sell it. If it's a land, we can also attach it and have it sold. The real question is this: what if I have judgment against Amma, and then in the steps of the execution, I go ahead and I seize a vehicle that doesn't belong to Amma, but maybe she was driving it, so I thought it belongs to her. Or Amma has been living in a particular house, which I think belongs to her. After I have attached it, then some unknown to me, it rather belongs to another person. Now, what can that person do? That is what brings issues related to interpleader proceedings. So in this lecture, we will discuss two main forms of interpleader proceedings. We will discuss the registrar's interpleader, and we'll discuss the stakeholders interpleader. So before the end of this lecture, you should be able to identify and define what we mean by interpleader proceedings. And you should know the procedure that follows after an interpleader proceeding. So I will not explain registrar's interpleader yet. I won't explain stakeholders yet. But bear in mind that there are two kinds of interpleader proceedings. So before I explain these two, I must first define what interpleader proceedings are. Now let us look at this case of Republic versus the High Court Accra. Ex parte Anyan, A-N-Y-A-N. Republic versus High Court Accra, ex parte Anyan, A-N-Y-A-N. Into brackets. Platinum Holdings Interested Party. Reported in 2009, Supreme Court of Ghana Law Reports at page 255. Specifically at page 261 to 262. This is what the court said, and I quote: interpleader proceedings. Interpleader is a proceeding by which a person from whom two or more persons claim the same property or debt, land, who does not himself claim the property or disputes the debt, can protect himself from legal proceedings by calling upon the two claimants to interplead. That is to say, claim against one another so that the title to the property of debt may be decided. Interpleaders may be divided into two types. The first is where a sheriff seizes or intends to seize goods by way of execution, and the person other than the judgment debtor claims them. Here, the sheriff initiates the proceedings to determine whether the property belongs to the judgment debtor and therefore can be seized, or to the claimant. For the purposes of this application, we will limit ourselves to this type of interpleader, which is known as the sheriff's interpleader, as the circumstances do not fall under the other type of interpleader known as the stakeholder's interpleader. End of quote. There are two things we can get from this quote. This quote that is from this case of Republic versus the High Court. S. Party Anyan, ANYN. Platinum Holdings Interested Party. Reported in 2009, Supreme Court of Ghana Law Reports at page 255. This quote gives us an indication that there are two types of interpleader. And it also lets us know what the sheriff's interpleader is. So I'll read it again. Interpleader is a proceeding by which a person from whom two or more persons claim the same property or debt, land, who does not himself claim the property or dispute the debt, but can protect himself from legal proceedings by calling upon the two claimants to interplead. That is to say, claim against one another so that the title to the property of debt may be decided. Interpleaders may be divided into two types. The first is where a sheriff seizes or intends to seize goods by way of execution. And the person, other than the judgment debtor, claims them. Here, the sheriff initiates the proceedings to determine whether the property belongs to the judgment debtor and therefore can be seized or to the claimant. Let me explain what is happening here. If there's judgment against a judgment debtor, and then the judgment debtor has refused to pay the judgment creditor, and the judgment creditor has taken steps towards execution by seizing property that the judgment creditor believes belongs to the judgment debtor. So, for example, Kofi has judgment against Kwame. And then Kofi took steps and had the writ of IFA to be issued. Now Kofi goes ahead to instruct the registrar and the bailiffs, and they went ahead to seize a property that Kofi believes it belongs to Kwame. Now remember, the seizure is done on the instructions of the registrar. So when the property is seized, it is in the custody of the registrar, and the registrar will have it until the sale has been conducted. So remember, there are three parties here. There's Kofi, who is the judgment creditor. There's Kwame, who is the judgment debtor. And there's the registrar, who has seized the item. So let's say the item that has been seized is a vehicle and is now being kept in the custody of the registrar. Three parties: Kofi, judgment creditor; Kwame, judgment debtor; and now the registrar. Now the registrar has taken custody of the vehicle, and now the vehicle is in the custody of the registrar. And then Cynthia indicates that the car that the registrar has taken rather belongs to Cynthia and doesn't belong to Kwame. Remember, Kwame is the judgment debtor. So Cynthia is now saying that the vehicle that is in the custody of the registrar rather belongs to Cynthia and that doesn't belong to Kwame. In other words, it is a third party who is saying that the property that is in the custody of the registrar, it doesn't belong to the judgment debtor, but it rather belongs to that third party who is laying a claim to it. So now the registrar is placed in the position whereby he has taken control of a vehicle. He has that vehicle in his custody. Cynthia, who is the third party, who was not a party to the suit, is saying that the car belongs to her. Meanwhile, the judgment debtor is there. And the judgment creditor is saying that no, it rather belongs to the judgment debtor. That is why the vehicle was seized. In effect, there are different people laying claim to the same property. Now, the one who has control over the vehicle, who is the registrar, he does not have any interest at all. The registrar is not saying the vehicle belongs to him. As a matter of fact, the only role the registrar is playing over here is that there was a vehicle and then there was a judgment. Judgment was obtained by a judgment creditor against a judgment debtor. The judgment creditor caused a writ of FIFA to be filed and issued. Now the writ of FIFA has been issued. Then what happens in practice is that the judgment creditor is the one who will tell the registrar that this car belongs to the judgment debtor, so seize it. Then the registrar, acting on the instructions of the judgment creditor, will go ahead and seize the vehicle and go and keep it. Now that the registrar has seized the vehicle, his work is to go ahead and ensure that the right procedure is followed for the property to be sold. So the registrar is never saying the property belongs to he, the registrar. He's only coming in as somebody helping in the execution of the process. Now, the parties involved so far are the judgment creditor that has judgment in his favor, the judgment debtor against whom we have judgment, and then the registrar who is not laying claim to the property. Now there's this new person that has come who is saying that the property doesn't belong to the judgment debtor, but the vehicle rather belongs to that particular person. For this purpose, called Cynthia. So look at the parties over here. We have a judgment creditor who told the registrar that this vehicle belongs to the judgment debtor. Then we have a new person saying that no, it doesn't belong to the judgment debtor. It rather belongs to me. So registrar, don't go ahead and sell the car. So you see that at this point, the registrar does not have any interest whatsoever in the property. He's supposed to go and sell, but people are making a rival claim to the property. What will he have to do? The registrar will then have to commence the interpleader proceedings for these two people who are laying claim to the property, the rival parties. They should come and tell the court who a rather belongs to. So the registrar himself doesn't have any interest. He was just having the item supposed to go and sell. And now people are saying it belongs to them. So all that the registrar will do is that he will commence interpleader proceedings, so that the people making rival claims to the property will come and prove their title. If the court adjudges that it belongs to the judgment debtor, then the registrar will go ahead and sell it. If the one laying claim is able to prove it, then the court will hand over the property to that particular person and withdraw from the execution. So take a look at the definition once again, bearing in mind this explanation I've given, and see whether you understand why it is called a registrar's interpleader. Because it is the registrar who is rather commencing the interpleader proceedings for the rival parties to come and prove their respective titles. So let's look at the definition once again from the case of Republic versus the High Court Accra, S. Party Anyan, ANYAN, Platinum Holdings, Interested Party. Reported in 2009 Supreme Court of Ghana Law Reports at page 255. Specifically at page 261 to 262. This is the definition once again, and I quote. Interpleader is a proceeding by which a person from whom two or more persons claim the same property or debt, land. So in this case, the registrar. So the registrar from whom two or more persons claim the same property or debt, land, who does not himself claim the property or dispute the debt. You see? So the registrar himself is not claiming the property, but he can protect himself from legal proceedings by calling upon the two claimants to interplead. That is to say, claim against one another so that the title to the property or debt may be decided. Interpleaders may be divided into two types. The first is where a sheriff seizes or intends to seize goods by way of execution, and a person other than the judgment debtor claims them. Here, the sheriff initiates proceedings to determine whether the property belongs to the judgment debtor and therefore can be seized, or rather to the claimant. Again, here the sheriff initiates the proceedings. So who is initiating the proceedings? The sheriff, because the sheriff is the one who is going to seize the item when he was told by the judgment creditor that the vehicle belongs to the judgment debtor. Now other people are laying claim to it. So this sheriff, who does not have any interest in the vehicle, will initiate the interpleader proceedings so that all the people laying claim will come and fight and will see who the property rather belongs to. So here, the sheriff initiates the proceedings to determine whether the property belongs to the judgment debtor and therefore can be seized, or to the claimant. For purposes of this application, we will limit ourselves to this type of interpleader, which is known as the sheriff's interpleader, as the circumstances do not fall under the other type of interpleader known as the stakeholder's interpleader. So what are we seeing so far? At least from this case of Republic versus High Court Accra, S. Party Anyan, ANYAN, Platinum Holdings, Interested Party, we know what a sheriff's interpleader is, or what a registrar's interpleader is. That this is when a registrar has seized property in execution of a judgment, and a person other than the judgment debtor is laying claim to that property. Because the registrar does not have any interest in the property, he will commence interpleader proceedings so that the people laying claim to the property would come and interplead and fight among themselves so that we'll see who the property belongs to. This is what we call sheriff's interpleader or the registrar's interpleader. So it's the registrar's interpleader because the registrar is the one that is commencing the interpleader proceedings. So let me read the definition once again for the final time so that you can get the full import of what you are explaining. I'm reading from Republic versus High Court Accra, S. Party Anyan, Platinum Holdings, Interested Party, reported in 2009 Supreme Court of Ghana Law Reports at page 255. Specifically at pages 261 to 262, and I quote. Interpleader is a proceeding by which a person from whom two or more persons claim the same property or debt, land, who does not himself claim the property or dispute the debt, can protect himself from legal proceedings by calling upon the two claimants to interplead. That is to say, claim against one another so that the title to the property of debt may be decided. Interpleaders may be divided into two types. The first is where a sheriff seizes or intends to seize goods by way of execution, and the person other than the judgment debtor claims them. Here, the sheriff initiates the proceedings to determine whether the property belongs to the judgment debtor and therefore can be seized or to the claimant. For purposes of this application, we will limit ourselves to this type of interpleader, which is known as a sheriff's interpleader, as the circumstances do not fall under the other type of interpleader known as a stakeholder's interpleader. To throw more light on all that we have said, I would once again read from a leading book in civil procedure in Ghana, quite recent. Remember, this recording is being made in 2023, but this book I'm referring to was published in 2022, and then we are referring to the book titled Civil Litigation in the High Court of Ghana, authored by Robert Smith Law Group, and the lead author, Bobby Banson, the first edition. And I'm reading from page 234, where the letter author provides as follows, and I quote, "It is possible that the ownership in a property or the proceeds from the said property attached in execution of a judgment debt is claimed by a person other than the judgment debtor. This new claimant under Order 44 Rule 12 of CI 47 would have given the registrar notice of their claim. Thereupon, the registrar would notify the execution creditor, who will either admit or dispute the claim of the claimant. Where such a circumstance arises, the registrar of the court or any other officer of the court who has in their possession the said property would apply to the court for a determination of who the property belongs to among the two. This is called the registrar's interpleader, otherwise called the sheriff's interpleader." End of quotes. Now, what do we have in this case so far? What do you have from this? We are being told that it is possible that the property that is going to seize in execution of the judgment debt, it will be claimed by some other person who is not the judgment debtor. In other words, you have gone to seize a car thinking it belongs to the judgment debtor, but it is possible that the ownership will be vested in a different person who is not the judgment debtor. When that happens, this new person, who will call the claimant will notify the registrar of their claim. The registrar, this vehicle belongs to me. When the registrar receives that notice, he will also notify the execution creditor. Remember, it was the execution creditor who told the registrar that this car belongs to this person. So, when the registrar receives the notice from the claimant, he will notify the execution creditor that this is what this person says, that the vehicle you told me to seize, that belongs to the judgment debtor. This claimant is saying it belongs to the claimant. What do you have to say? Do you admit or do you dispute it? If the execution creditor disputes it, then he will have to file the interpleader proceedings for the two of them to come and then litigate, and let's find out who it rather belongs to. Because the registrar is the one commencing the proceedings, it is called interpleader. It's called the registrar's interpleader or the sheriff's interpleader. How can we distinguish this from the stakeholder's interpleader? Remember, this one is called the registrar's interpleader because it is the registrar who is commencing the interpleader proceedings for the two people to come and then litigate so that we'll find out who it belongs to. How then do we distinguish that from the stakeholder's interpleader? Before I explain stakeholder's interpleader, let me give an example so that before we get the explanation, we would understand what stakeholder's interpleader means. Now, think about an example like this. That you you are a warehouse owner and there are some goods in your warehouse. Now, two different people are saying that the goods belong to them. You do not have any interest in the goods, except that you are keeping the goods as a warehouse owner. But one person is saying the goods belongs to him, another person is laying claim to that same goods that you have in your possession. And they all want to sue you for you to return the goods or to give the goods to them. Think about it. Your only interest as a warehouse owner is that you are keeping the goods. But two different people are laying claim to that same goods. And if you are afraid that if you give it to the first person, the other person will sue you that why did you give it to him? If you give it to the second person too, you are afraid that the other person will also sue you. So what do? You do not have any interest in the goods over there. You only want to give it to whoever will be the rightful owner. You are not a registrar. You are a warehouse owner. You want to know who you will give the item to. What do? You can commence an interpleader proceedings, which we call the stakeholders interpleader. So that in this case, the people who are laying claim to, let's say, the tractor in your warehouse, they will come and interplead among themselves so that when they resolve and you know who it belongs to, then you can hand over the item to the person. This is called stakeholders interpleader because you are not the person you are not a registrar. You are a person that has possession of some goods and you are expecting to be sued by two different people who are laying claim to the same property. Rather than giving it to one person and then you not knowing what the consequence will be, you can commence an interpleader proceedings for the two people to come and fight so that we will know who the item belongs to, that you know who to give it to. Let me give another example. I'll give three different examples before I begin to look at what the law says. Another example is this. You are occupying a premises and then you've been paying rent to a particular, let's say, landlord. The landlord has now passed. After his death, two different people are laying claim to that same property. Meanwhile, it is time for you to pay your rent. You don't know which of those two people you are supposed to pay your rent to. Meanwhile, the rent, what you paid for so far, is expired. And this one is saying that give me the rent. The other person is saying that give me the rent, I'm the owner. You don't know who you are supposed to give it to. And you know they can all sue you that you should pay the rent to them. What do? You can commence an interpleader proceedings because you are not saying the house belongs to you, but you are commencing a stakeholders interpleader. The two people should come and fight. And let them tell the court to determine who it belongs to so that you know who you hand over the rent to. It's called stakeholders interpleader. Let me give a third example before I begin with the law itself. Let's say you are a bank. And then there's a company called Too Sure Company Limited. And Too Sure Company Limited has paid an amount of 500,000 cedis into an employee's account. But they made a payment by mistake. So they quickly come and tell you the bank, I have paid 500,000 cedis into my employee's account, but the payment was by mistake. Return the money to me. As a bank, you want to find out from your customer, who's the employee, whether indeed the money was a mistake or not. Because how do you return money from a customer's account when you don't have the customer's instructions? So you are trying to find out from the customer, you're not hearing from him. Then Too Sure Company Limited, they sue you, the bank, for you to return the money to them. Because you don't want trouble, as a bank, two different people may be laying claim to the money. You don't know where it belongs to, but you don't have any interest in the money. You only want to give it to who the rightful owner is. You can commence stakeholders interpleader so that Too Sure Company Limited and the employee, they should come and find out and litigate over who the money belongs to so that you know who you return the money to. So that is what stakeholders interpleader is. When you under liability for a debt, money or goods, and you are expecting to be sued by two or more people over that same thing, but you don't have an interest in it, you can commence a stakeholders interpleader for the people laying claim to it to come and then assess their ownership so that you give it to whoever is the victor. And it's called stakeholders interpleader because in this case, it's not the registrar who is commencing the interpleader proceedings. Now that I have given examples that are supposed to make it simple, let us see how it's been defined from the authorities. And I'll begin with the book titled Civil Litigation in Ghana, Civil Litigation in the High Court of Ghana, authored by Robert Smith Law Group, and Bobby Banson is the lead author. And I'm reading from page 233. It reads as follows, and I quote. And the explanation I'm about to read is supposed to explain stakeholders interpleader, and I quote. This occurs where a person under liability for any debt, money or goods, example, a warehouse owner, has been or expects to be sued by two or more rival claimants to the property. If he has no interest in the dispute, he can apply for relief by way of interpleader. That is, a hearing at which the rival claimants will be made to interplead, i.e., argue against each other and not him. End of quote. So you see, the explanation given by the author fits into the examples I've given. That you are a person, you are under a liability for a debt, let's say rent, and you are expecting to be sued by two or more people who are laying claim to the property. You have no interest in the building. You can apply for relief by way of interpleader. That is that at a hearing at which the rival claimants will be made to interplead, that is, argue against each other. There's a case that really explains this stakeholders interpleader. And if we go through the facts and holding of the case, it will simplify stakeholders interpleader. And it's a case of Attorney General versus Bank of West Africa, which is reported in 1965, Ghana Law Report at page 245. Now let me read the brief facts from the head notes. It reads as follows, and I quote. Acting under a mistake of fact, an employer paid a sum of money into an employee's bank account. Upon discovering his mistake, the employer wrote to the employee's bank demanding repayment of the sum involved. The bank delayed the repayment while seeking instructions from its customer. Before the receipt of instructions from the customer, the employer sued the bank for restitution of the sum paid. The bank applied to the High Court for relief by way of interpleader summons. In the affidavit accompanying its application, the bank indicated its willingness to pay the sum claimed into court or to dispose of it as the court might direct, pending the determination of the employer's action. Before the bank's application came up for hearing, they paid back the sum claimed to the employer in pursuance of instructions received from the employee, which had meanwhile been received. On the date fixed for hearing the application, therefore, it was withdrawn by counsel for the bank. Upon counsel for the employer asking for costs against the bank on the ground that the amount should have been paid before the rate was issued, the trial judge refused this application and awarded costs against the employer rather, on the ground that this action was ill-conceived. From this order as to cost, the employer appealed. It was held in holding 3 as follows. That although the appellant had a cause of action against the bank to recover the sum paid, the conclusion reached by the trial judge that the bank and not the appellant was entitled to costs was correct because in the circumstances, the bank's step in applying to the High Court for a relief by way of interpleader summons was a wise and prudent one. The trial judge's conclusion was thus right, although the reasons for that conclusion were untenable. the facts and the surrounding circumstances show that the bank was not guilty of misconduct, for no prudent banker or shrewd businessman will readily refund money which has been lodged with him on behalf of his customer under a mistake of fact without first informing the customer of a demand for repayment, if in fact the demand is made by the payer. End of quotes. What are we seeing from this case? This case is a case in which a bank has received an amount of money, and the person who paid the money is saying that the money was paid wrongly. And the bank says that they want to find out from the customer first. They haven't heard from the customer, and you sue the bank. What the bank do? The bank also applied for interpleader summons, stakeholders interpleader. That, well, the customer and then the employer should come and fight, and let's see who it belongs to. The court held that that action taken by the bank was a wise and prudent one. And so that affirms what we call stakeholders interpleader. The court noted in holding 3 that the conclusion reached by the trial judge that the bank and not the appellant was entitled to costs was correct because in the circumstances, the bank step in applying to the High Court for a relief by way of interpleader summons was a wise and a prudent one. So we know what registrar's interpleader is, and we know what stakeholders interpleader is. Registrar's interpleader, when the registrar has seized an item on the instructions of a judgment creditor, and then now other people apart from the judgment debtor are laying claim to that same property. The registrar doesn't have an interest in it, so he will commence proceedings by way of registrar's interpleader or sheriff's interpleader, for that the people laying claim to it will come and interplead, and we'll find out who it belongs to. Stakeholders interpleader is when you're not the registrar, but you're having an item or money or goods, and you're expecting to be sued by multiple people, 2 or more people, who are laying claim to the same property. If you don't want trouble and you don't have an interest, just commence stakeholders interpleader. You have to pay the rent. Commence stakeholders interpleader. Let the people laying claim to the property, let them come interplead, so that we will know who it belongs to. That is stakeholders interpleader. This is by way of introduction. Now let's see where in our civil procedure rules we have this interpleader proceedings provided for. You will see them under Order 48, Rule 1 of the CI 47. Now that you have the background already, when I read Order 48, Rule 1, without telling you, you should be able to tell which one is registrar's interpleader, which one is stakeholders interpleader. So I'll read Order 48, Rule 1, A and B, and you try and find out which one will be the registrar's interpleader, which one will be the stakeholders interpleader. Order 48, Rule 1 reads as follows, and I quote: a person may apply to the court for relief by way of interpleader. A, where the person seeking relief in this order, referred to as the applicant, is under liability for any debt, money or goods, for or in respect of which the person is or expects to be sued by 2 or more parties in this order, referred to as the claimants, making adverse titles thereto. Or B, the person seeking relief is a registrar or other officer of the court, charged with the execution of process by or under the authority of the court, and the claim is made to any movable or immovable property taken or intended to be taken in execution under any process, or to the proceeds or value of any of the property by the claimant, other than the person against whom the process is issued. Take a critical look at Order 48, Rule 1, A and B, and find out which one will be the registrar's interpleader, which one will be the stakeholders interpleader. I'll read Order 48, Rule 1, A again. A person may apply to the court for relief by way of interpleader, where the person seeking relief in this order, referred to as the applicant, is under liability for any debt, money or goods, for or in respect of which the person is or expects to be sued by 2 or more parties in this order refer to other claimants, making adverse titles thereto. It is clear that this order 48 rule 1a will refer to the stakeholders interpleader, because the person being referred to over here is expecting to be sued by two or more people laying claim to the property. He doesn't have any interest. He will apply to the courts so that the claimants will come and interplead amongst themselves. So that's called stakeholders interpleader. Then under 48 rule 1b, the person seeking relief is a registrar or other officer of the courts who have been charged with the execution of process by or under the authority of the courts. And the claim is made to any property, movable or immovable, taken or intended to be taken in execution under any process, or to the proceeds or value of any of the property by any claimant other than the person against whom the process is issued. This will be the registrar's interpleader. So at this point, it is clear what we mean by stakeholders interpleader. We also know what we mean by registrar's interpleader. Now that we know this, what happens after everything? Now, what happens when there is the registrar's interpleader? To lay the foundation for the explanation about what happens thereafter, I'll once again read from the leading book, Civil Procedure, Civil Litigation in the High Court of Ghana, authored by Robert Smith Law Group, Bobby Banson, lead author, first edition. It's a quite recent book and it's very instructive in civil procedure. This is what the learned author says at page 234. Like I'm saying, pay critical attention to what I'm about to read because it will set the foundation for what happens after there's a registrar's interpleader. And I quote, "It is possible that the ownership in a property or the proceeds from the said property attached in execution of a judgment is claimed by a person other than the judgment debtor. This new claimant under Order 44 Rule 12 of CI 47 would have given the registrar notice of their claim. Thereupon, the registrar would notify the execution creditor, who will either admit or dispute the claim of the claimant. Where such a circumstance arises, the registrar of the court or any other officer of the court who has in their possession the said property would apply to the court for a determination of who the property belongs to among the two. This is called the registrar's interpleader or the sheriff's interpleader." End of quote. What I want you to note over here is that it makes reference to this new claimant under Order 44 Rule 12. So let's go to Order 44 Rule 12 and let's see what it says. Order 44 Rule 12 reads as follows, and I quote, "A person who makes a claim to or in respect of a property taken or intended to be taken in execution and the process of the court, or to the proceeds or value of such any property, shall give notice of the claim to the registrar, and shall include in the notice a statement of the person's address for service." Again, a person who makes a claim to or in respect of a property taken or intended to be taken in execution and the process of the court, or to the proceeds or value of any such property, shall give notice of the claim to the registrar and shall include in the notice a statement of the person's address for service. So this is what is happening. That you are saying the property belongs to you and doesn't belong to the judgment debtor. Meanwhile, the property has been seized and is now in the custody of the registrar. What do? Serve the registrar with the notice. Tell him that it rather belongs to you and then give him your address for service. So that now if we want to serve you with anything, because the notice you gave to the registrar, it has your address, we shall communicate everything to you through that address. So, Order 44 Rule 12 Rule 1 says that a person who makes a claim to or in respect of property taken or intended to be taken in execution and the process of the court, or to the proceeds or value of any such property, shall give notice of the claim to the registrar, and shall include in the notice a statement of the person's address for service. Order 44, Rule 12, Sub Rule 2. On receipt of a claim under Sub Rule 1, the registrar shall give notice of it to the execution creditor. He shall give notice to the execution creditor, who shall within 4 days after receiving the notice give notice to the registrar, informing the registrar whether the execution creditor admits or disputes the claim. It means that execution creditor, you are the one who told me that this property belongs to the judgment debtor. I've seized it. Now this new person is saying the car belongs to her. I'm giving you notice. Do you admit or do you dispute it? So what happens when the execution creditor disputes it? Order 44, Rule 12, Sub Rule 3. Where the registrar receives a notice from the execution creditor under Sub Rule 2 disputing a claim. Again, where the registrar receives a notice from the execution creditor under Sub Rule 2 disputing a claim, or the execution creditor fails to give the required notice within the period mentioned in that sub-rule, the claim made under sub-rule 1 and the claim under sub-rule 1 is not withdrawn, the registrar may apply to the court for relief. So you see, where the registrar receives a notice from an execution creditor under sub-rule 2 disputing a claim, or the execution creditor fails to give the required notice. The notice we are referring to over here is about whether he's giving the notice about whether he admits or disputes the claim. So when the registrar receives a notice from the execution creditor under sub-rule 2 disputing a claim, or when the execution creditor fails to give the required notice within a period mentioned in that sub-rule, and the claimant too has not withdrawn the notice of claim, then the registrar may apply to the court for relief. In other words, you have filed a notice of claim. I have notified the execution creditor, admits or disputes. If you dispute, I have to apply to the court for relief by way of interpleader. If you don't dispute, but you also don't say anything, and the claimant has also not withdrawn the notice of claim, the registrar would have to apply to the court for relief. And that relief is what we call the interpleader proceedings that is applying for. So, that is what we call the interpleader proceedings. So look at Order 44, Rule 12. An application for relief by the registrar under this rule shall be made ex parte to the court seeking an order that the claimant and the execution creditor shall appear before the court on a date specified in the order for the issue between them to be determined. This is the interpleader proceeding, that an application for relief by the registrar shall be made ex parte to the court, seeking an order that the claimant and the execution creditor shall appear before the court on a date specified in the order for the issue between them to be determined. You remember when we explained registrar's interpleader, that the registrar has custody of an item. He doesn't have any interest in it, but some people are laying claim to it. What will he do? He will apply to the court. Now you are being told under Order 44, Rule 12, Sub Rule 4, that an application for relief by the registrar under this rule shall be made ex parte to the court, seeking an order that the claimant and the execution creditor, they should appear before the court in order for the issue between them to be determined. Because the registrar is merely having custody of the vehicle, and people are making claim to it. He has to apply to the court so that the people will come and lay their respective claims for the court to resolve it. But what if after the registrar received the notice of claim from the claimant, saying that the property belongs to the claimant, and then the execution creditor, when I was given notice, he admitted it? Sometimes it happens. There are times when you can go and see a person's vehicle thinking it belongs to the judgment debtor. But when the execution creditor brings the notice of claim, saying that it belongs to the when the claimant brings the notice of claim under 44 Rule 12, saying that it belongs to the claimant, sometimes if it's a vehicle, they'll bring the Form 6 You see their names over there. You go for DVLA. You know it doesn't belong to the judgment debtor. Why would you want to waste the cost time? You can just admit it. That doesn't belong to the judgment debtor. So what happens when the registrar receives notice from the execution creditor admitting a claim? Order 44 Rule 12 Sub Rule 5 says that where the registrar receives a notice from an execution creditor under Sub Rule 2 admitting a claim, the registrar shall forthwith withdraw from possession of the property claimed. And having withdrawn, the registrar may apply to the court for an order restraining the bringing of an action against the registrar in respect of the registrar having taken possession of that property. So the execution creditor admits the registrar just withdraw from the possession of the property. Now, what happens when the court hears the proceedings? Now, the registrar has commenced the interpleader proceedings. What happens at that hearing? Look at Order 44, Rule 13 of the CI 47. It reads as follows. And I quote, where on the hearing of proceedings, pursuant to an order made under Sub Rule 12, under Rule 12, Sub Rule 4, all the persons by whom adverse claims to the property in dispute, in this rule referred to as the claimants, appear, the court may A, summarily determine the question in issue between the claimants and the execution creditor, and make an order accordingly on such terms as may be just. Or order that any issue between the claimants and the execution creditor be stayed and tried, and may direct which of them is to be plaintiff and which one is to be defendant. So you see, all the court will have to do is that you have to give you a date, and the court will summarily determine the question in issue between the claimant and the execution creditor. So for example, the claimant saying the vehicle belongs to the claimant. The court will have to resolve the issue between the claimant and the execution creditor summarily, so that we'll find out who the car belongs to, and we'll know whether we can go ahead with the execution or not. There's one thing that you have to bear in mind. There are times when people just want to frustrate the court process. And so they have, for example, you are going to seize the property of the judgment debtor. Then because the judgment debtor wants to just frustrate you, they will go and call some people to just come and file a notice of claim. Meanwhile, they know that it doesn't belong to those people. They only want to stay the proceedings so that you can't go and sell the thing quickly. So there are times when the court will be there and then a claimant to file a notice of claim saying the vehicle belongs to them. But when they call them to now come to the court so that they bring their documents, they will never show up. So what will happen? What is the outcome of such things? So the vehicle is there, they can't go out to sell it. Somebody is saying that it belongs to the person. When you invite the person to come to the court too, he doesn't come. What should happen? Sometimes it's so bad. Then for a long time, the vehicle is still in the custody of the registrar. If it's a vehicle, sometimes it may even be deteriorating. So what will happen? Look at the 44 Rule 13, Sub Rule 2. Where a claimant, having been duly served with notice of an order under Rule 12.4, fails to appear, or having appeared, fails or refuses to comply with any order made after the appearance, the claimant and all persons claiming under the claimant shall forever be barred from prosecuting the claimant's claim against the registrar. So if you were supposed to appear before the court, because after the registrar commenced the interpleader proceedings, the court will invite claimant and execution creditor, come. If you, the claimant, you don't come, or when you came, they asked you to file your document showing that it belongs to you, you don't file it, then the court shall bar. So the court shall forever bar you, the claimant, from prosecuting your claim against the registrar and all persons claiming against the registrar. So you can't come and claim anything against the registrar anymore. So that is as far as the rule, the decisions the court can make when you commence the interpleader proceedings are concerned. Now, look at Order 44 Rule 13, Sub Rule 4. For the purpose of this rule, the court may give such judgments or make such order as we finally dispose of all questions arising between the judgment, between the claimant and the execution creditor. So as between the claimant and the execution creditor, the court can make such orders that would finally dispose of that between you, the claimant, and the execution creditor, if the property belongs to the claimant. When the court resolves that one, it shall finally dispose of all the questions between the claimant and the execution creditor. But what if you're not happy with the decision given by the court and you want to appeal against it? Order 44, Rule 13, Sub-Rule 5 provides that an appeal against any judgment or order given or made under Sub-Rule 4 shall be filed within 14 days from the date of the judgment or order. And so now we have explained what Stakeholders Interpleader is, and we've explained what Registrar's Interpleader is. So I shall wrap up our discussion by reading from the case of Salama versus Sharani. Salama is spelled S-A-L-A-M-A versus Sharani, S-H-A-R-A-N-I, reported in 1973, 2 Ghana Law Reports at page 364. I'm going to read the words of Aban J as he then was. And this is what the case says, and I read. Interpleader proceedings should not be confused with an ordinary action. The most important object of these proceedings is to enable the deputy sheriff who has seized the property and is now in possession thereof to obtain a relief and to get a decision of the court as regards the person to whom he has to release the property. The claims in respect of the property are made against the deputy sheriff, and he is, in the technical sense, the defendant, since the rival claims are being made against him. So that in a way, the interpleader proceedings are intended for the benefit of the deputy sheriff, inasmuch as the decision of the court in the proceedings, as I have stated, would give him a relief and would also enable him to know the right person to whom he should release the property. The deputy sheriff therefore issue out the interpleader summons. Again, the deputy sheriff therefore issues out the interpleader summons to compel all the parties making the claims against him to come to court to establish the validity of their respective claims. And since he has no title himself, he drops out of the subsequent proceedings altogether. End of quotes. This is the end of our discussion on interpleader proceedings. So remember that in this lecture, we have explained what interpleader proceedings is. We've been able to explain what we mean by the registrar's interpleader. When the registrar is the one that has seized the item and rival people are laying claims to it, the registrar has no interest. He will commence interpleader proceedings so that the rival parties will come and lay their respective claims for the court to determine. We've also dealt with stakeholders interpleader, and I gave an example. You have a warehouse, you have some goods there. Rival people are laying claim to that particular good. You don't have an interest in it as a warehouse owner. All you want to know is that who does it belong to, so that I give it to you. So over there, as we've seen, you and the person can commence stakeholders interpleader, so that the people making rival claims will come and interplead for the court to determine who the property should be ultimately given to. And that is the end of our discussion on interpleader proceedings. Thank you.